The next case we have is Greg Hansen versus Katrina Pruitt. Is Mr. Hansen here?
Yes.
Okay, hold on just a second. Oh, no, I don't want to do that. Just a second. I messed everything up here. Try to pull up the case. Okay, just a second. Oh, that's not it. There we go. Okay. Okay, just a second. Okay, okay, there we have Mr. Hansen and Katrina Pruitt and someone on behalf of PMI.
That's yes, Patrick Caballero on behalf of Ms. Pruitt and the intervener PMI. Thank you.
Okay, thank you, Mr. Caballero. Thank you, Mr. Hansen. Let me just swear in all the witnesses at one time. Do each of you swear to tell the whole truth and nothing but the truth?
Yes.
Okay, thank you. The first thing we need to do is clean up the parties. Ms. Pruitt needs to be dismissed as a party, and we're going to add PMI Experts LLC as interveners and counter plaintiffs. And then Mr. Hansen will be denoted as a counter defendant. So that will be the first thing that those will be the first orders entered in the case. So we can get that taken care of right out front. Okay. Mr. Hansen, you are requesting 3790.93 from the court from PMI, and as succinctly as possible, can you explain to the court why you want that and why you believe the court should give that amount to you?
So let me, I'm not a lawyer, so let me ask how to do this. So I have a complete timeline of what happened. Do you want me to go through that timeline, or do you want me to give us?
No, I want this as short as possible because we don't have a lot of time today.
Okay.
For you to tell me, you're asking for this amount of money, and you tell me why you believe that PMI owes that money to you and how you came up with that figure.
Sure. So I hired PMI and Katrina Pruitt as a professional property manager for a couple houses that I wanted to lease out, and I wanted to have professional representation to manage the properties and get the tenants in. We went through the process. Miss Pruitt inspected the houses multiple times, and when the tenants went to turn the gas on, they called, or this is what I was told. I was told that they called the gas company, and the gas company gave them instructions to open a permit with the city and get an inspection done, and then come back and get the gas turned on. We kind of went round and round in that process because that was a complete misrepresentation. That was not true at all. I contacted a licensed plumber because the only people who can open permits are a licensed plumber. So I contacted a licensed plumber. They didn't understand why we were doing that, but they recommended we could go ahead and do a pressure test. So I ordered that and paid for it. While that was going on, someone came out and turned the gas on without approval from the utility, without a permit, and without me knowing. And based on that, I decided that to call the utility and find out a little bit more about what was going on, because things just weren't adding up. At that point, I was told by the utility what was really going on, which is they do an inspection when they turn the gas on. They didn't need a permit. They didn't need a pressure test. They just needed to come out, inspect the gas, and turn it on. So I realized that I was being lied to. So I went ahead and
Your Honor, I just very quickly, obviously, I know you don't want a lot of interruptions from the counsel, but just objection on the hearsay.
I
And
understand.
closing statements. Thank you.
I understand. So noted. Thank you,
I
counsel.
apologize if I was using the wrong words. What I was told was incorrect. And so I scheduled to have the gas company come out. When the gas company came out, nobody would let them in the house. So I rescheduled the gas company to come out, decided to put the gas in my name to make sure that nothing could go wrong again. So I had that happen. I sat with the inspector, went through the inspection process. Then I was told that 2 more repairs needed to be done. There was a utility box that needed to be replaced, and there was an electrical problem with the dishwasher. So I went out to the house to inspect because of what happened with the gas. I knew that was most likely not true. And it turned out that both of those issues were not true. There were no utility boxes that needed repairs. It was just a cable wire, and cable wires are not powered. They just get screwed back into the wall. But more concerning was somebody had disconnected the dishwasher, run an extension cord across the kitchen, and plugged it into a wall outlet. The tenants were from the UK, so they didn't really know any better about what was going on. And so when they were told there's an electrical problem and we're going to run an extension cord, even though there's kids in the house, across the kitchen and plug it into a wall outlet, they didn't know any better. So I disconnected the extension cord, plugged it back into the proper outlet, tested that the dishwasher was working. Then I showed the tenants how to operate the disposal and the dishwasher. And the next day I canceled the contract.
With PMI, right? You're saying?
Yeah.
Okay.
Now, on 2 weeks later, I finally received my first ledger so that I could see some of the costs that were involved, and I let Ms. Pruitt know that I would not be paying for I got a plumbing invoice for the person who turned the gas on without the utility knowing, and I said I wasn't going to pay for that. Then on March 20th, I sent my first demand letter because I had not received any payments. And all I had was the informal ledger. So I asked that the full amount be paid, which was just based on the contract, which was $8,380.91. I did actually receive a partial payment after that. On April 3rd, I sent demand letter 2, asking for $3,790.93, which includes my expenses, includes all the fees associated with the contract, and includes the plumbing fees for whoever had turned on the gas without the utility knowing.
Okay. And that's the amount you're requesting today?
That's the amount.
Okay. And you're asking that back from PMI?
Yes.
Okay. All right. Anything else?
No. I have a statement, but I know that we're trying to keep this quick, so I'm not going to do that unless you ask me to.
Okay. Excellent. Thank you very much. And I have looked at the letters and things that you submitted. Okay, Mr. Caballero.
Your Honor, and in advance, I might note, I did not receive a copy of any exhibits that Mr. Hansen may have provided, so I don't actually know what you're referring to. Just
He just brought the exhibits today, and it's attached to the file. Can you, Miss Mary, can you email him a copy of all of that?
Let me just verify the email address.
We just got this today as well.
I would object to the inclusion and reliance on the exhibits since I not had a chance to review them before trial.
They're just the demand letters that I sent to Ms. Pruitt. And some pictures.
Well, as I understand, JP3 does not have a rule that requires this evidence be submitted prior to trial, counsel. But if you want to take a look at it, there are 2 letters and an invoice.
If I can get an email link to that, I'll proceed. But if I can get an email link to my email address, I will try and do that as efficiently as possible.
Yeah, Miss Mary is trying to send you a copy right now.
Is the email address pcaballero@rrsfirm.com your email address?
That is correct.
Okay, I'll send it to you right now.
Thank you. And in the meantime, Judge, would you like me to proceed with Ms. Pruitt?
Yes, if you would please. He has rested his case.
Okay. Ms. Pruitt, what's your occupation? Oh, and you can unmute Ms. Pruitt.
I'm a licensed realtor and own a property management company.
And is that PMI?
Yes, it is. It's PMI Austin Experts.
Okay, what does PMI do?
It's a full service asset management company. We provide professional management for residential, commercial, and HOA.
And did you enter into an agreement on behalf of PMI with Mr. Hanson?
I did.
Okay, Your Honor, may I share my screen for exhibits?
Yes.
Thank you. Oh, I just sent the request.
Oh, yeah. Mary, can you?
I went ahead and accepted that. You should be able to share your screen.
I can do it now. Thank you. Let me find the correct document.
And Mr. Caballero, I went ahead and just emailed those exhibits, so you should be getting it shortly.
Thank you very much. I appreciate that. And
Okay.
just so I'm clear, is the property management agreement showing on the screen?
Yes.
Okay, thank you. Ms. Pruitt, do you recognize this document?
I do.
What is this?
This is our property management agreement that we were using at the time that Mr. Hanson and I signed an agreement.
Okay, and that's between PMI and Mr. Hanson?
It is.
And if I scroll down to the bottom, I apologize for the quick moving, but here at the bottom, is this signed by you and Mr. Hanson?
It is.
And this is a record kept by PMI in the course of its business, right, Ms. Pruitt?
It is.
Your Honor, may I offer Exhibit B for evidence?
Yes. So admitted.
Okay. And your relationship, PMI's relationship with Mr. Hanson was via this contract, right?
Yes.
Okay. If I scroll down in this contract to, hold on, it's paragraph. I apologize. It's a long document. Do you see the section titled Owner's Representations?
Yes.
And within this section, is there a subpart B regarding property condition?
There is.
I want to read this as efficiently as possible. Am I correct that this language includes a clause that says owner and manager are obligated under law to disclose to a tenant or prospective tenant any known condition that materially and adversely affects the health or safety of an ordinary tenant? Owner is obligated under the property code to repair any such condition for a tenant. Owner represents that. And then subpart 2 states, owner is not aware of a condition concerning the property that materially affects the health or safety of an ordinary tenant except as stated below in this agreement or in any addendum. Did I read that correctly?
Yes, sir.
Okay. With regard to your agreement, did you and Mr. Hanson discuss the property before you executed the agreement?
Yes, we talked about the property.
And did Mr. Hanson describe any material conditions on the property affecting the health or safety of any tenants?
We did discuss a hole in the exterior wall in the backyard that he was going to have fixed.
Okay.
But in regards to the gas, no, we did not.
Okay. Was there anything else that he covered before you entered the contract?
Not that I'm aware of.
Okay. Did PMI Performance Management Services under the agreement?
Yes, it did.
And what did PMI do regarding this property?
It's not everything's Pruitt.
Yes, ma'am. Okay. So we went in, we did an initial inspection to identify any issues that needed to be corrected. We went to Mr. Hanson because there were no utilities and told him we had to have the utilities on in order to show the property. And he was actively working on the hole in the back wall. And we then gave him a list of things that needed to be corrected for us to place a tenant in there.
Okay.
If I disagree with something, should I speak up or should I wait?
Hold on, you'll have a chance to address
Okay.
everything that you'd like to, just make note of it, and you'll have a chance to respond to everything that's being said.
Okay, thank you.
And can you explain the issue regarding the hole in the wall that you mentioned?
I believe that there had been a previous water leak right there. And when we originally saw it, it was the sheetrock on the inside had not been fixed, so you could see daylight through. He was able to get the interior corrected, and he said he got the outside taken care of, but that actually was not the case. From the inside, it was closed, but from the outside, I think the day the tenants moved in, their dog ripped the black plastic off and tore I think it's clothing out of there.
And I'm showing you what's marked as Exhibit I. Is this a photo of that hole?
Yes, sir.
Okay. And this is is this a problem for renting a property to a tenant?
It is. The interior was fixed. The exterior is still open to well, they had 4 little kids. This was should have been completely closed up.
Okay. And why is this a problem for the tenants?
Because one, at the time that they moved in, it was super cold temperatures. Not having that insulation and that wall closed off, it's letting cold air in. And that subjects them to freezing pipes.
Okay. And was this entire condition disclosed to you before you entered into the agreement?
He told me he was working on things, but he said this would be fixed before the tenants moved in, and he said he had it taken care of, and from the inside it was closed off.
And so was it fixed before the tenants moved in?
No.
Okay. Were there any problems with the water heater?
Yes, I went to Mr. Hanson. We sent him some photographs and told him that the hot water heater had so much damage it needed to be replaced. So I believe he replaced it himself. He might have hired someone, but I don't have any record of how it got replaced.
Okay, and I'm showing you Exhibit K. Is this that water heater?
It is.
Okay, and did he disclose the condition of this before you entered into that agreement?
No.
Is this a danger for the tenants?
It is.
Okay, and why?
Well, because you can see that there was something that was not running properly. Otherwise, I don't believe, I'm not an expert on hot water heaters, but I don't believe that kind of burn happens if it's functioning properly.
Okay, if these conditions have been disclosed to you before you entered into the agreement, would you have entered into the agreement as is?
Likely not, because there were a lot of things in that house that needed to be corrected that that weren't corrected when we started trying to lease out this property.
So in addition to what I've shown you, there's other things that also needed to be addressed.
There were.
And did you suffer any damages based on the additional work?
We spent money going out there time after time to check to see if things were taken care of.
And had you known about these problems, what would the additional costs that have been included in the contract, what would they have been?
Every time that we went out there, we would have charged him an additional $75.
So how many total visits? So what would the total be of damages based on this issue?
There were at least 5 times I went out there to check simple things like, was the yard cut and cleaned up? And it wasn't. And that just went on several times.
Excuse me, counsel, Ms. Pruitt, are you saying the water heater was not updated with the new one?
No, ma'am, it was.
It was, okay.
Yes.
And just to clarify that, the water heater, when you signed the agreement, looked like this corroded one, right?
Yes,
And you didn't know that when you signed the agreement, right?
that's correct.
And it had to get fixed up before the tenant occupied the property, right?
Yes.
Okay. Now, when the tenant moved in, were there any additional problems that arose?
Yes. I believe he was talking about an electrical box. That actually was a cable line coming out of the wall that I wanted to go and buy a $5 part and have it installed so that it gave us something, because it was just an open hole, something to tether the plate to the wall, because we were putting literally a 1-year-old in that house, and the wall plug was about 4 to 5 inches from that plate. I wanted that thing so that it could not be pulled off the wall. And he and I went back and forth on that, and like many other owners, he wanted to do a lot of it himself.
Okay. Did the tenants reach out to you about an issue regarding the freeze?
Yes.
Okay. And what happened?
They called me on January 30th. They said they had talked to the gas company and they wouldn't turn the gas on because the gas had been off for 9 months. And they told them specifically, you have to get it inspected from the code enforcement before the gas company can turn it on. I called the gas company and got that same information from them. I called the city of Pflugerville. I talked to them and had a inspector call me back. He said that was correct. All because it had been off for an extended period of time.
Did
So
Mr. Hanson explain to you before you signed the agreement that the gas had been turned off for several months?
No.
Okay. What did you do about the situation with the gas for the tenants?
Well, it was 29 degrees outside. I called my plumber and asked him to go over and see what he could do. He went over, he was able to turn the gas on and run pressure tests to verify that everything inside the house was okay. And I let Mr. Hanson know I got the gas turned on.
And did you bill for those services?
I got a bill from Riojas Plumbing and I billed Greg for that amount.
Okay. Going back to the agreement that we looked at earlier under Section 4, authority of manager. If you scroll down to point 22, am I correct that this provision says that the manager may hire contractors to make emergency repairs to the property without regard to the expense limitation in Section A21? the manager determines are necessary to protect the property or the health or safety of an ordinary tenant.
Yes,
Okay, and did you authorize the plumber to make those repairs because of the health or safety of the tenants?
I did.
Okay, and that's because it was freezing, right?
It was freezing. I either needed to get it fixed or put them in a hotel.
Okay. Did PMI do anything to cause any of the problems we've talked about?
No, sir.
Okay, was PMI responsible for the fact that the gas had been off for several months before you entered into the agreement with Mr. Hansen?
No, sir.
Okay. And did you speak to Mr. Hansen about that issue with the gas and the freeze?
Yeah, we talked several times back and forth over this whole thing.
And did he authorize you to have someone come out to fix the gas?
I asked him how am I supposed to handle this? Because I have an entity telling me I need a permit. I have the gas company telling me that it needs an inspection. And his response was, I guess you need to hire a plumber. Actually, he said licensed plumber.
When Mr. Hansen terminated, he referred earlier to himself terminating. He terminated by letter on, hold on real quick. Showing what's marked as Exhibit F. This is a February 27th letter. Do you see that?
I do.
And is this the letter that he wrote to terminate the agreement?
That's the letter I received.
Okay. And going back to the property management agreement, in Exhibit 3, here on paragraph 3B, the automatic extension, does this state that unless either party provides written notice of termination to the other party at least 30 days before the expiration date, this agreement will automatically extend on a monthly or annual basis until either party terminates by providing at least 30 days written notice to the other party? Did I read that correctly?
Yes, sir.
Did Mr. Hansen provide 30 days written notice?
He did in that letter on the 27th.
Well, he provided you notice.
Yes.
But did you receive payment for the ensuing 30 days?
No, sir. I refunded him March management fees.
Okay, and how much would you have been owed for that additional 30 days period under the contract?
For just that one property or for both?
For this one property?
For that one property would have been $124.50.
Okay, and what about for the other property?
I think that one was 100, probably 118. No, I'm
Okay.
sorry, it was 120.25.
All right. Did you knowingly lie about any of the work you did for Mr. Hansen?
No,
To your recollection, did you lie about any work that PMI performed for Mr. Hansen?
no. And can I make a comment? I don't know what he's talking about with the extension cord. That wasn't us. So I'm not quite sure what
Okay.
he, yeah.
Regarding Mr. Hansen's testimony earlier, was there anything that he talked about with regard to what the tenants claimed that was PMI's responsibility?
I'm sorry. Repeat that?
With regard to Mr. Hansen's testimony earlier about the dishwasher cord and all that, was PMI responsible for any of that?
No, we weren't.
Okay. Past witness.
Counsel, you requested 627.29 in the counterclaim. Is that still the amount y'all are requesting, or how much are you requesting in the counterclaim?
So the counterclaim today calls for $375 for the additional visits that PMI had to make to the property.
Right.
And then the additional $124 that Ms. Pruitt just claimed for Wild
Right.
Senna, and $120 for the separate property that's separate and aside from attorney's fees.
And what attorney's fees are you requesting today?
I submitted them via exhibit L56, attorney's fees and costs.
Uh-huh.
Uh,
What's the total right now? 5714?
5714.95. In addition, there are 2 additional hours of work performed since this was submitted last week.
So the total for attorney's fees as of now?
It would be this plus $1,050.
Okay. And that's everything you're requesting today?
That is correct.
All right. Do you have any additional witnesses you're going to call?
No.
Okay. Let's take an 8 to 10 minute break and we'll come right back and we'll
Thank
pick
you.
up with Mr. Hanson. Thank you. Thank you very much for the break. Excuse me, Mr. Henson, if you'd like to respond to the information, you may do so now.
Yeah, that would be good. Thank you. So when we originally talked about this contract, I thought that I was dealing with a professional property management company. The keyword being professional, I was planning to defer to what the property management company needed in order to do their job. So I was looking for guidance, and if anything came up, I was willing to jump on it immediately. On our initial call on December 2nd, I was told that the house would be inspected. I offered access to the lockbox to get into the house if that was needed. On January 4th, I was contacted to get current lockbox codes again, and I gave those codes. On January 7th, I was asked to look at the water heater. The water heater was functional, but I think we saw the pictures. I didn't like the way that it looked either. So I immediately called the plumber, and on January 9th, a new water heater was installed. At that point, I was asked by Ms. Pruitt to turn the electricity on and immediately contacted Austin Energy. I was not asked about the gas or the water, which are 2 different utilities to do each of those. On January 13th, I asked again, are there any open issues with the house? And on January 14th, I was told, no, everything looks good. This was before any leases were signed or any tenants moved in. When the issue with the gas came up, unfortunately, I was going off of the information that I was being told by what I believed was a professional property management company. When they told me that there needed to be a permit pulled with the city, my concern was that if we're going to pull a permit, you have to have a licensed plumber. If you try to pull a permit and the plumber doesn't have a license, it causes big problems down the road. So what I was told on the 30th was the plumber that Ms. Pruitt knew didn't really know what was going on. I wasn't really convinced that, because I don't know the plumber, I wasn't really convinced that they were licensed. She told me specifically, because the licensed plumber that I was working with, the bill is attached. I sent it to the clerk. That plumber at least knew how to run a pressure test and felt like that was a good next step. Ms. Pruitt asked me to go do that, so I did that. I scheduled the test with the plumber that I had. It wasn't that happened on the 30th. The gas was turned on without the utility knowing on the 4th. By that time, the pressure test had been completed, and so I had already seen from the licensed plumber that the pressure test was complete and there were no issues with the house. That's what made me realize that something odd was going on here, and that was why I called the utility. So on February 6th, I called the utility and just asked them to explain to me, this is the first time I had talked to them, asked them to explain to me what was going on. You know, why are we having trouble turning the gas on? What is it that they need? And that was when I was explained for the first time that there is no permit requirement. That's why a permit was never pulled. There is no record of a permit being pulled with the city because a permit is not required. And we had just been wasting time and money chasing bad information. It turns out that the inspection that the utility does is just par for the course. When they turn on the gas, they like to do an inspection. They will even do the inspection if you just ask them. I just turned the power on in a different house, or the gas on in a different house, and I knew because of this experience that you can just ask the utility, hey, will you come out and do an inspection? And it's a good idea to get that inspection done. But the key thing is they do that inspection at the same time that they turn the gas on. There's not two events, it's one and the same. They do the inspection, they turn the valve, the gas is on, they activate the account. That should have happened on February 8th, but nobody was there to let them in, even though I was told that somebody would be there to let them in. So I had to schedule the next one, even though I was paying a professional property management company that couldn't show up and couldn't talk to the tenant to make sure that the gas inspector could get in and look at the house. So I scheduled it on my own, turned the gas on in my name, only because I wanted to make absolutely sure that everything was done correctly, and I no longer trusted that anything was going to be done correctly. At that point, that was the next day before the gas was turned on, the next day on the 9th, that's when I was told that there was a safety issue regarding an outlet. And I was not told it's a cable box. There is no box. It's just a wire. It just gets reattached to the, so I was told about this repair. It's not that I wanted to do it myself. I just no longer trusted that I was getting the right information. I was told about this electrical problem that I had to get repaired. And when I got there and I showed pictures of the plug where the tenants were from the UK, they are not going to, number one, they're not going to unplug a dishwasher. And even if they were, I specifically asked on the night, if the power is not getting to the dishwasher, did somebody check the breakers and did somebody check the GFCI outlets? Because those outlets sometimes are GFCI. And I was told yes. That answer came from PMI. It did not come from the tenant. So this whole imaginary electrical problem came from PMI. It did not come from the tenant.
Anything else?
I think that is it.
Okay. Mr. Caballero, any additional evidence?
I just have a couple of quick questions for Ms. Pruitt. First of all, regarding Mr. Hansen's testimony just now on the condition of the electrical and the gas, was PMI responsible for any of the problems with the gas or electric in the house? You're muted.
My apologies. No, in fact, this issue started on the 30th. According to his testimony, he doesn't even have anybody out there to start looking at it until the 6th. I had it turned on the 30th by our plumber. who did the pressure tests and took care of all of that. Now, what he did in the background, at that point, we had a contentious relationship over the gas. And all I can do is go off of what the tenants are telling me, that the gas company is telling them. I in turn called City of Pflugerville and spoke to their older inspector, and he pretty much confirmed the exact same thing. This is because it was off for 9 months. Now, all the things that Mr. Hansen says, that very well may have been what his plumber said. And yes, it passed inspection with his plumber because our plumber had already done the inspections. And as far as the permit, I can't tell you. We can only go off of the information we're being given by the two entities, City of Pflugerville and the gas company.
Okay. And again, PMI had nothing to do with the fact that the gas was off the property for several months before you entered the contract, right?
Correct. We had nothing to do with that.
And then going back to Exhibit B, that property management agreement, I'm going to share my screen again. I want to go down to section 15, liability and indemnification. Does this state that manager is not responsible or liable in any manner for personal injury to any person or for loss or damage to any person's real or personal property resulting from any act or omission not caused by manager's negligence, including but not limited to injuries or damages caused by, and then there's several things listed, including number 2, acts of third parties, number 3, freezing or leaking water pipes, and number 5, a dangerous condition or environmental condition on the property. Did I read that correctly?
You did.
Okay. The issues that are being described with regard to the gas and electrical and the condition of the property, were any of those caused by PMI?
No, they weren't.
And just since I had a chance to see it just now, if I'm looking at the materials provided by Mr. Hansen correctly, in his demand letter where he's seeking $8,380, I'm going to share the screen. Are these amounts for January? Are these amounts for the entirety of the rent and lease for January, February at Wild Senna?
Who are you asking?
Ms. Pruitt.
I couldn't see it.
Was January rent of $490? Was that a partial rent payment based on when the tenant moved in?
Yeah, they moved in on the 24th of January. Or they took custody on the 24th of January. I don't think they moved in until the 29th.
Okay. Did you remit all owed amounts to Mr. Hansen under the contract?
I did.
Okay. Did you withhold anything that did not belong to PMI?
No, I did not.
Did PMI benefit in any way from a personal financial nature from any of the invoices that were passed along for the utility work that we've described today?
No, we did not.
No further questions.
Okay,
Can I,
Mr. Hansen, you get the last word. You're the plaintiff. You get the last word.
so here's the actual timeline of the events with the gas, and I have records of everything. So it was reported on January 30th that they were having trouble turning the gas on. I asked them to call Atmos Energy. What I was told was that Ms. Pruitt had spoken to Atmos Energy and that we needed to pull a permit with the city. That was not correct. If at that point, if I had called Atmos Energy like I did on February 6th and gotten the real answer, we could have gotten the gas turned on the next day. The fact that the gas was off does not matter. It does not matter because the gas company will come out and do an inspection the same time that they turn the gas on. same time that they activate the account. I would expect a professional property management company to, number one, know that, and number two, communicate the correct information to me so that we can avoid these problems entirely. All I can see is a bill for nearly $700 for somebody to come out and take 5 minutes or less to turn the gas valve on, turning the gas on without the utility knowing. That's what happened. That happened on February 4th. That is what caused me to call the gas company on February 6th and find out what was really going on. And that was when I learned that, yes, where the money went for this $700 of 5 minutes work, I don't know. But I do know that it was dangerous. It might have been illegal. No, it should not have happened. And I definitely should not have to pay for it. And when I got the reports about electrical repairs that needed to be done and realized that somebody had created the condition very, very intentionally to create those repairs needing to be done, and that it took me 30 seconds to reverse it and explain to the tenants how everything works, I realized that that event was the same as the gas event. It was the exact same thing. These were fraudulent repairs that were set up specifically because they were easy to remediate, and then you could charge a very big bill attached to that repair. And that was what caused me to cancel the contract, and that was why I would like the fees returned and any available damages, because as it's hard enough being a very responsible and responsive landlord with these tenants, and I fixed everything within a day or two of knowing about it. And it just makes it that much harder when I'm dealing with what I think of as a professional property management company, and I'm getting inaccurate information that is tied to illegitimate repairs and illegitimate expenses.
Okay. So, Mr. Henson, I think you've very well wrapped up what it is overall. Mr. Kabiri, do you want to take about 2 minutes and just wrap up what your entire position is?
Yes. First, in terms of plaintiff's pleadings, the only thing that he pled in his petition was that the defendant knowingly and intentionally provided him with fraudulent repair requests and invoices, and that he's seeking damages. That's fraud. That's his only claim in this case is fraud, which is a heightened pleading standard of clear and convincing evidence, which Mr. Hansen has not met. Even if there had been a mistake here, which we're not acknowledging, but Mr. Hansen has to prove that it was done knowingly and intentionally, and there is not clear and convincing evidence of that. Ms. Pruitt testified that she did the work she did in good faith, that PMI responded to what it considered an emergency situation regarding a freeze. It got a plumber out to turn the gas on in a freezing environment, and that does not constitute fraud. So that's one. Second, even if we rely on the go back to, let's say it was a breach of contract claim, PMI's actions were all justified under the contract. In particular, we talked about the clause that specifically gives PMI the right as property manager to exercise repairs in an emergency situation. And again, PMI testified that this was an emergency situation because it was a tenant with a family, with the children, in freezing conditions. And PMI exercised its authority in good faith. As an extension, even as an extension of that in the contract also specifically absolves PMI of any liability for except for its own negligent acts. So even if there were conditions in the property, for example, a faulty gas line, issues that Mr. Hansen has raised regarding, utilities, there's no evidence those are PMI's fault. In fact, it's Mr. Hansen's property. He was aware of the condition of the property for months before PMI was involved. And so again, PMI is absolved of liability for anything that was not due to its own negligence. By contrast, PMI entered into the agreement based on certain material conditions that Mr. Hansen had to represent the condition of the property to the extent that it affected the health and safety of any tenants. He did not do so. He did not disclose that the gas had been turned off for several months, which in fact caused a problem when the freeze occurred in early February that PMI could not have known about. Second, there was a hole in the exterior wall that Mr. Hansen claimed to have fixed, but again, it was exposed at the time the tenants moved in. And again, that was a dangerous condition for the tenants who were in the property. He did not disclose those. He did that to induce PMI to enter into the contract. And in doing so, that caused damages that were testified to by Ms. Pruitt. One, for making extra trips to the property. And then two, after his termination, without 30 days notice, per the terms of the contract that we cited, PMI incurred additional damages for the lost fees for that additional amount. Finally, in terms of the damages claimed by Mr. Hansen for $8,380 or whatever amount that is, that seeks a return of essentially, well, we can rely on the letter. I don't need to testify about that, but there's no basis for those damages. PMI performed work, and even if there had been an invoice that was submitted improperly, the only invoice that was submitted by, in this case, is one that was done based on the emergency authority of PMI Property Management, had the right to submit it, and there's no basis for that money going back to Mr. Hansen when he expressly contracted for PMI to have that right.
Okay.
Also, attorney's fees, it's in the contract, and so that's why we're seeking that today, Your Honor. This was
Okay.
not PMI's fight. They responded and had to counterclaim.
Thank you very much. First, let me thank the witnesses and the parties for appearing in court today. Thank you, counsel, for appearing. I appreciate y'all being here and presenting the testimony that was offered. With regard to the causes of action, I find that the plaintiff has not established a cause of action for fraud. With regard to the counterclaim, I find that the counter defendant and intervener has established a cause of action for $619 in damages and for $67.64 in attorney's fees plus court cost. As I said earlier, each party does have at least 15 days to file a motion for new trial and at least 22 days to appeal. And we will get copies of the judgment out to the parties at the conclusion of the hearing today. So thank you once again for attending.